And then I wanted to introduce our speakers briefly. This is Selena Moreno and then Julia Longoria. And both of them are from Texas Rio Grande Legal Aid and have experience with handling the type of cases that we're going to be talking about today, specifically cases dealing with youth ticketing. So I'm going to turn it over to them to address the things we need to know before we represent children in these cases. Thank you very much for being here.
Thank you. Hi, everybody. My name is Selena Moreno. I'm from the San Antonio office of Texas Rio Grande Legal Aid. And I just wanted to thank Keenan so much for organizing this, and also Morgan Craven, who actually was an attorney at Trala with us and also has handled these cases. So she's also a real asset to you. I especially want to thank Julia Longoria. This is her first day back from maternity leave, and I dragged her all the way out here to Austin. So she's awesome. And she's going to be a really great resource for you as well. Very, very excited to have all of you here. This is an area that Trala is very passionate about. We see the criminalization of youth for very, very minor misbehavior or behavior that you and I would have gone to the principal's office for, or even just had a phone call home to mom and dad. So this is such an important area because school ticketing is one stop along what's called the school to prison pipeline. Has everybody here heard that term, school to prison pipeline? Pretty much? Okay, well, just to kind of give you a sense of what it is, it's basically kids being funneled out of the classroom and into the juvenile and also the criminal justice system. And we're going to focus today on the criminal justice system. Before that, I just wanted to very quickly tell you a little bit about Trala. Most people have probably heard of legal aid, but when you think of legal aid, you probably normally think of somebody calling to get a divorce or needing help because they're about to be evicted. So this is a very recent effort that legal aid has embarked on. It's only been around for a few years. So when you're feeling nervous about taking a case, just think, well, hey, even the people who have been doing this for a while have only been doing it for a couple of years. So I hope you just get in here and take on these cases full force. Just so you know, though, Trala does cover 68 counties. I know Austin is one part of that, but if you're interested in moving also beyond Austin to the surrounding counties, Bastrop, et cetera, that's also something that's a possibility. So when you think of the school to prison pipeline, often we've thought about getting in trouble kind of as a linear process, right? Where you get a phone call home because you're in trouble, you go to the detention after school, to the principal's office, maybe you're going to get suspended if you keep getting in trouble. And then for the really bad kids, they're going to alternative school and then eventually being expelled. Then after all of that inside the school system, you would assume that, okay, kids are now going to be introduced into the juvenile justice system, going to juvie or being on probation. But that's actually not true anymore. In fact, the vast majority of juvenile court cases nowadays, between 80 and 90%, are actually not in juvenile court. They're in these justice of the peace, the JP, and municipal court, in municipal courts where you would go, for example, if you had a traffic ticket. And so a lot of people don't know that. It was very shocking to me when I first found that out. Most of these cases do not go into juvenile court where you have an attorney that's appointed to you, should you not be able to pay for one. Similarly, you might assume that linear process, but we have a lot of clients where if one of our clients got in trouble, their parents sometimes weren't even called to let them know. They just 6 months later, they get a piece of paper in the mail summoning them to court because their child disrupted class. And so the school system has increasingly relied on these Class C tickets in these JP municipal courts as a way to discipline kids. And you might have heard in the newspapers, there's been articles about it. It's a phenomenon that people have called passing the paddle, for when people back in the day used to get paddled. So why is this important? Well, kids that are being criminalized this way are much more likely to drop out. We see parents that are pleading with us to help them out because they just can't pay for these fines that they're getting in court anymore, and so they want to pull their kids out of school. So that's one example, and the other example is just once you're criminalized. I mean, you think of a 12-year-old, showing up in front of a judge, being criminalized. Your self-concept also changes, and so that's just one example of how this leads to kids' entry into the juvenile and criminal justice systems. One of the things that I think is so interesting, because when you talk about this at a kind of a big picture level, you'll hear, and my husband's a teacher, I love teachers, but you'll hear teachers say, what are we going to do if we don't have this as a stick? That we can't issue these citations or can't call the police officer at school to issue these citations. What are we going to do? And one of the things that I think is really interesting is, yes, right now we're a climate where the education funding is less than what it needs to be, but it's also a matter of how resources are used. So one thing that I thought was really scary is that for every 250 kids, there's one police officer, but for every 437 kids, there's one counselor. And so you can see how an adjustment of resources might change the climate a bit. Has anybody heard of Texas Appleseed, the organization? They do such great work in advocacy and also in research. And they've done a whole bunch of records requests all across the state, but there's really not great data in this area because there's no legislative requirement. But just wanted to, the data that we do have, it shows that students of color, especially black students, and also kids that have special needs, they're very much overrepresented in who's getting ticketing. And also, people might assume, well, if you're going to court, you really did something, really, really bad. But most of these cases are actually for nonviolent offenses. And so that's what the data that we do have shows. So what are some of the type of cases that you would handle? One of the most common in Texas, I think it's about 100,000 every single year, are truancy cases. In JP and municipal courts, they're called failure to attend school cases. Simple assault, anybody have an idea what that would mean? Simple assault, remember from law school? It's not, I'm getting in a fight and I'm beating Morgan up. It's, it's more of, it can be either assault by threat. So, hey Morgan, I'm gonna kick your butt after school. That's a Class C misdemeanor offense. Or, if I, push by Keenan, but don't hurt her, don't cause bodily injury, that's also considered simple assault. So these are the kind of cases that you'd be seeing. Very, very low level offenses. Disruption of class is probably the most controversial, and disruption of transportation are probably the most controversial offenses, because what does that really mean? What does that look like? Disrupting class, I don't know of any middle school student who has not disrupted class at some point. And so this likewise for being rowdy on the bus. Disorderly conduct, that's something that you've heard of in the adult setting, but it also applies to school. So that the most common one is disorderly conduct for using profanity or flicking somebody off, right? That's something has been criminalized in Texas. There have been some legislative adjustments in the last session, and there are several bills this legislative session that could change the landscape of these cases. And if that happens, we will definitely make sure that we provide those updates for you. But one of the changes that was significant in last legislative session was that if you are in the 6th grade or younger, you cannot be ticketed for several offenses. So before that, we would handle cases where you'd have a 6-year-old come in for missing school, for failure to attend school, and they would be charged criminally and go before one of these courts. So I mentioned juvenile, and I mentioned JP and municipal courts. And so a lot of people are confused by that because they assume all the cases go to juvenile court. But most of these cases, like I said before, are handled in the JP and municipal courts. Often, your very presence in these courts is going to make a huge impact in one of your clients' lives. If you haven't ever sat in one of the docket calls for truancy or for disruption of class, you'll see it's like a cattle call. There's just some of the bigger cities like San Antonio, like Austin, you'll see 100 kids in one docket call, and you're not entitled to the automatic appointment of counsel in these cases. So virtually no one is represented in these cases. So your very presence will shake things up because the prosecutors are not used to having to negotiate with anybody. In fact, a lot of times there aren't even prosecutors around when you'd like to meet with them. And so sometimes, for example, for truancy cases, you'll have a school district representative serving as a prosecutor, which is obviously not okay. But your very presence has a really high chance of making a big impact in a child's life and getting the case dismissed.
Can I add to, my mic, I don't know how to turn it on, I'm sorry. Also, a lot of clients or a lot of kids are being told that they can't speak to a prosecutor unless they plead no contest. So just you showing up or even letting them know that they can plead not guilty and still speak to a prosecutor changes the game a lot for them.
Thank you. And actually that's a really good point, because if you were to go to court and as a child and plead not guilty, what are you told? Well, normally you'll talk to the court clerk when you show up, go to the window, and they'll tell you, okay, well, here's your court date. If you're going to plead not guilty, here's your trial date. It's set for this day, and if you're 15, you're like, all right. You can imagine how you would feel as a 15-year-old trying to represent yourself, because parents are not allowed to serve as attorneys. So trying to represent yourself, and that's not even if you're if you have special needs, if English is not your first language, if you don't come from a family with a lot of education, you can imagine that the barriers stack up. So again, your presence would be really crucial. So that's one difference when we're talking about juvenile courts, where people can go to juvie or on juvenile probation versus JP municipal courts. So that's one, is that you don't get automatic appointment of counsel. Another thing is a level of offense. So although juvenile courts will hear Class C misdemeanors sometimes, for the most part, if you're getting a Class C misdemeanor, the lowest level offense in the state of Texas, you will normally not be in juvenile court. You'll be in one of these courts. Once you get to Class B and higher, that will go into juvenile court. Another difference is that when you get adjudicated, it's a finding of guilt, versus if you're in a juvenile court, it's not considered, even though there's, for those of you who took juvenile law classes in law school, you know that it's kind of quasi-criminal, right? But you don't get a criminal record in juvenile court, where you do get a permanent criminal record in these JP and municipal courts. And so that's another big impact that you can have just by your very presence, because there are several collateral consequences to these kind of records that I'll talk about in just a second. The other difference is punishment. So what happens when you get stopped and for speeding, right? Class C misdemeanor. You usually have to pay a fine or do some kind of deferral. In juvenile court, there might be a restitution. If you stole something, you have to pay it back. But there's no fines in juvenile court. And here, for a Class C misdemeanor, you can be fined up to $500 for every ticket. So sometimes we'll see a family that was out of town, car broke down in another state, couldn't get back to call the school, but they couldn't get back, so they missed too much school and got charged with truancy both by both the parents and the child. So that's already 3 tickets, 1 family, and you think I'm exaggerating, but I promise I'm not. $1,500 potential fine. For the families that we represent, indigent families, that is, I mean, a lot of people that we see end up coming to us even after the case is already over, because they just look at that and say, well, there's no way I can pay it. So unfortunately, sometimes they don't even show up to court, which is, we tell them is don't do that. But it's a huge amount of money for these families. And then lastly, confidentiality. That's a huge difference, because as you know, in juvenile court, you can seal your records. There are provisions in the law there's non-disclosure and there's expunction provisions in the law to handle Class C misdemeanor cases. But even when a child reaches a certain age and their case is set for non-disclosure, there's so many private companies nowadays, and there's such a backlog in these cases. There's almost 300,000 of these cases every year in Texas that are not traffic related. And so just the backlog and all the information out there for private internet companies, where if you were to do a search on a record, even if that case has been supposedly under non-disclosure, a lot of times they will still come up. And so, I've had clients that, actually Julia ran a project at Legal Aid for youth experiencing homelessness, and worked with youth all the way up until 23. And so we'd have 19, 20-year-olds come in saying, I cannot get a job, I can't get a job because what's coming up on my record is an assault charge. And so the records don't differentiate between domestic violence, felony assault, and, hey, Morgan, I'm going to kick your ass, They just don't. So that's something that in terms of perpetuating poverty, perpetuating homelessness, I mean, that's something that, it seems small, right? It seems like, oh, this is just one ticket, but it can have lasting impact on the people that you're coming to help. So again, why take on these cases? Well, the fine alone, but some of the other collateral consequences that I haven't mentioned yet. If you're applying to college, not every college will ask for it, but some colleges will ask, have you been charged with, or have you been convicted of a crime? And so, of course, the answer has to be yes. Even if you've been charged with a crime, a lot of job applications now also go beyond just have you been convicted, but have you been charged with a crime? And so, in a tight economy, if I'm competing with Julia and I have, criminal conviction, and we're both, on an equal playing field, who are you going to pick? If I have a disorderly conduct for flicking off my principal. So that's another collateral consequence. When I was doing, when I had a court case in El Paso, I spoke with some of the JP judges out there, and found out that there's a county outside of El Paso that actually, if you're in public housing, a failure to attend school conviction can result in your family being kicked out of public housing. So there's a lot of different things. If you want to join the military and you have an assault or disorderly conduct, it's not that you will necessarily be completely excluded, but it's something that they will see and consider. And then, although in JP municipal courts, when you get a ticket, you're generally not going to be put in jail because it's a fine-only offense, and same with these. But let's just say that Keenan gets a truancy ticket as a teenager and does not pay her $500 fine or $250 fine, whatever it may be, and turns 17. Well, right upon turning 17 in Texas, as you probably know, you're considered an adult for the criminal justice system purposes. And if you haven't paid your fine by the time you turn 17, there's something that will, an order that will be issued, capias pro fine is what it's called. And I'm saying it the Texas way, it's a Latin. But you know, you can be jailed. You can, if you're determined that you could have paid and didn't, or even that you can't really afford it, but there's other things you could have done, you can actually be put behind bars for time until you serve your time enough to pay off that fine. So this is something that's another consequence that you might see in these types of cases. And then one of the things that I find pretty disturbing is this actually has education consequences as well. And when I say education, I mean a deprivation of education. So one of the things in the Code of Criminal Procedure, which is the code that you would most look to aside from the penal code in these cases, when you're looking at how are these courts run, the Code of Criminal Procedure is controlling. If you were to take a look at the Code of Criminal Procedure, you would see that in these cases, the judges have a lot of discretion. So you'll see your West Texas judges or your small rural town judges say, well, I'm going to have this kid write an essay on yada, yada, yada. And so that might be the only thing that they have as a punishment. But they also have the discretion to say, well, you're kind of moving along a little slowly, not up to speed on the year you should be. I'm going to order you to get a GED. And so that's a straight deprivation of your education. And so that's another more dire consequence that these cases carry. So let's just take an example. Like I said, truancy or failure to attend school is one of the most common charges. And by the way, if you have questions, please feel free to interrupt me. So what does failure to attend school mean? You'd actually be surprised on how strict the law is in Texas. So missing only 3 days or parts of days, having only 3 unexcused absences in a month's period can lead you to have a ticket for failure to attend school. And so that's why you see sometimes, I know for me, I still get woken up. Like I mentioned that my husband's a teacher. He, as a prank, put me on this call list. They have, Sean Paul, and they have, all these different celebrities calling to wake you up in the morning. Make sure you go to school. So I still get woken up by at 6 o'clock in the morning sometimes by these phone calls. But you'll see a lot of an effort to get these kids to school by the school districts because the attendance is, if you study education policy or in the newspaper, attendance is correlated with how much funding the school district gets from the state. So, school districts have, in addition to, wanting their kids to be there, they have a financial incentive to get their kids there. So that's why the law is very, very strict. Missing only 3 days, that's really not a lot. Let's say, when you're sick, you don't necessarily go to the doctor the first day, right? Maybe not even the second day. Okay, I have a fever the second day. Okay, I'm going to go to the doctor. So that's already 2 unexcused absences that you would get before you went to the doctor. You only need 3 in a month's period. Or more broadly, if you're talking about a longer period of time, so within a semester, if you have 10 or more unexcused absences. And I put on here, and I think this is important because a lot of people don't realize this, a lot of parents don't realize this, that it's not just days. It's days, the law says days or parts of days. And so even if I went to the doctor that 3rd day in the morning and don't get a doctor's note for the rest of the day, if I miss that afternoon, that's a part of a day. And so that would count as one of the day. So already right there, in just a quick example that I've shown you, you can be charged with failure to attend school. And I would say that there's schools that are much more reasonable than others. You're going to think, okay, no way they're going to actually file charges in those cases. And some of the schools won't. They will take preventative measures to make sure, okay, what's going on call home, but we do see cases where just the very minimum is met and these kids are charged.
I think part of it too comes from a wrongful thinking on part of truancy officers that sometimes these kids need help and getting them to court is a way for them to get help, which, as Selena has pointed out, doesn't really work out for a lot of them.
Right. You'll see both the benevolent truancy officers and also the benevolent judges saying, well, and principals. So, like for example, I had a client that was beat up because he refused to be in a gang, and so he was jumped by a bunch of gang members, and rather than the school actually taking the time to interview them, each of the students, they said, oh well, if there's ever a fight, we just call it mutual combat and let the courts figure it out. So already you're exposing that child who's actually a victim in the situation to the criminal justice system without really taking the time to do your job and determine whether or not this case should be in criminal court. So I mentioned last session, there was, since the 90s, the pendulum has been swinging towards more and more strict school discipline and criminalization laws for these types of cases. And so you're starting to see people are outraged, and the pendulum is starting to swing back a little bit. So last session, for truancy cases, the legislature passed a law that requires that schools put in their complaints that they tried truancy prevention measures and that those measures failed. What does that mean? Well, the law did not define what truancy prevention measures meant. But if I were you and I have a case where a child has a chronic medical condition that keeps them out of school for several days, and there's a valid defense, and you realize that, okay, well, what did the school do? Has the school had the social worker talk with him for the school district? Have they had the counselor meet with him? Have they called home to figure out? Or did they just give a paper, at the beginning of the school year saying, this is what the law says, 3 or more days, parts of days, 10 or more days in 6 months. What does that mean? Well, we don't really know. It means different things based on how proactive the particular school district is. But if I were in court and I'm arguing, I'm going to argue that, well, I'm going to ask these kinds of questions. Well, did this child need special education services that they were not receiving, and that contributed to their absences? Was this child homeless? Was this child running away from an abusive parent? Just having that initial conversation sometimes with your client will quickly answer some of these questions for you. And so if they answer those questions for you, the question is, well, why didn't the school know this? And so sometimes, even though the law is very vague, you can argue. And again, just your presence there is going to really shake things up. And you asking those questions can often lead to the case being outright dismissed. So I won't go through all of this, but basically there are cases in the education code where the truancy laws are laid out, do have a lot of different excuses or valid defenses of why it's okay to miss school. And so, these are just a couple. One of them that's important to note is that a lot of times parents will write a note for their child and say, well, the school's going to take that, right? Well, the school does take that sometimes, but under the law, they do not have to accept as an excused absence a note from your parent. So, you can think you're being this great parent, and every single time your child has to miss school, let's say they have a medical condition, you'll just assume that the school is not going to go and turn around and press charges. But that assumption is not always correct. And so just know that that's something that's permissive under the law, but the schools are not mandated to excuse parent notes. So everybody close their eyes. And think about when you were in middle school. And I'm going to read you the definition of disruption of class. This is part of the definition under the Education Code. And tell me if you think that any of your behavior or your friend's behavior falls under this category. So the Texas Education Code defines disruption of class as offense to include emitting a noise of an intensity that prevents or hinders classroom instruction. So raise your hand if you think that anything you've done could have possibly fell under that category. And please share if you have a particularly juicy incident. All right, so I saw a lot of hands. You can see how vague those laws are. And the reason why that matters is because when we go back and talk about the disproportionality in these cases of special education students who might have emotional disabilities, for example, and then the disproportionality in terms of race, that's something you have to ask yourself, how do the laws, when they're written so broadly and open for such interpretation, how are they being implemented? And you wonder where that disproportionality comes from. And it's not just a question of race or whether you have special needs. I mean, you can imagine if you're a teacher and you're just annoyed with this one particular kid, you just kind of don't want to have to deal with this kid because you're trying to get on and teach the rest of your students. You can see how that provision in the Education Code, you can use that as one of your discipline tools in your toolkit, whether or not that's right or wrong. So I want to make sure that we leave time for questions, but just a couple of practice points. You always want to advise your client to plead not guilty. Because what happens when a child, like Julia was saying, when they go and they plead no contest or guilty, automatically you reduce the incentive a prosecutor has to negotiate with you in a pretrial conference. And so when you're taking on one of these cases, the first thing you normally do is go and talk to a prosecutor. You go show up to the court, find out, or call the court in advance, when is the prosecutor going to be available to talk with? Because you want to try to get your case dismissed immediately, dismissed outright, rather than a dismissal after a probationary or deferral period. And so once your client pleads no contest or guilty, there's really little incentive to negotiate if you're a prosecutor. One of the things that I mentioned, and I'm not going to go through it, it's beyond the focus of what I wanted to talk to you about today, but a lot of the cases, you've already heard me kind of allude to other underlying issues that are going on in students' lives that may impact why they're in court or not. So whether they have special needs, whether they're homeless, whether they're having other school discipline issues. There's a lot of cases that if you wanted to take on, or if you wanted to call Trala and legal aid and say, hey, there's this other part, I can't take this case on, but this is something you might want to look at, and maybe you can take it on. For example, a lot of times when a kid is getting in trouble for disorderly conduct, they might also be sent to alternative school at the same time. So there's a school discipline case, and then there's a school ticketing case. And I know for the purposes of this, this project, I think that the focus is going to be on school ticketing. But I wanted to let you know that on the last half of your slides, I talk a little bit more about special education and about school discipline, so that if you are interested in those cases, or if you think that might apply, you can kind of know what to look for. And again, one of the reasons why I'm so glad that Julia's here is that she's going to be the point person on this project from legal aid, and so she can provide valuable technical assistance. You can call her up and ask her questions that you might have. Because you're in Austin, I think that what we're saying about just being there, having your presence there, even more so. I mean, I'm not going to say that Austin's perfect, but I think compared to a lot of other jurisdictions, you have a much better chance of getting the judge to agree to what you want, if you are not able to dismiss the case outright during a pretrial conference.
How does the actual client retention process work? I mean, usually minors can't actually contract, so how can they hire an attorney to represent them, of course, even for free?
Right, and so what we do, and that's a great question. What we do is we have, the parent, if they have a parent or guardian, sign for them on a representation agreement. And while this is not binding, we also ask the child to sign as well, just more for symbolic purposes, because as you know, the child is the person that is your client, not that child's parent. And you might find a case where there's a conflict. Let's, for example, a truancy case. I've had clients where dad is disabled and wants his son to drop out of school, or at least miss a lot of school, so that he can work and help support the family. And that's an example of a clear conflict where the child is being charged with truancy, but and maybe the parent as well. And so there's you obviously would not be able to represent both without a really great conflict waiver agreement. I think we have till 1, right?
Yeah, we can go a couple minutes past.
Okay.
Maybe 1:05.
It's sort of related to that question. Maybe you could do like a big picture timeline of what a case looks like from
Yeah.
getting ticketed at school to receiving a summons
Sure.
to contacting one of volunteer attorneys to.
Absolutely. So
Before we get there, can I just ask one question?
Sure.
And that is just existing guidelines that are out there.
Yeah.
So we'll know whether to what extent AYLA needs to create them for all the volunteer attorneys.
No, absolutely. And
It'd be great to have a big picture.
so I just want to make sure. So there's a bunch of information in your PowerPoint that we're not going to get. Like I said, we're not going to get to all of the special education and school discipline stuff, because that's really only if you're interested in those areas. But one of the things that's in your PowerPoint is our website. It's www.trla.org/youth rights, and that's in there. What it's going to point you to is these nifty little youth guides that we've created based on the most common offenses. So failure to attend school, disorderly conduct, disruption of classes, assault, and then if you happen to be working with a child that there's a lot of undiagnosed and underdiagnosed children that that are ticketed with these cases. In these cases, so for example, you might have a client who's also in special education or receiving some kind of accommodations for a disability. There's a booklet specifically on how to work with a child with special needs. So if you are working with the child with special needs who's charged with disruption of classes, you would want to take a look at both of these. And so they have their sample forms in here on, for example, if there's a fight, or let's just say disruption of class, right, case, and the teacher, and because he's angry, wants to press charges, so calls the police officer. But later, once you've talked to the teacher and said, hey, these are some of the consequences that can happen if this child is convicted in a criminal court. Maybe the teacher changes their mind and is agreeing to sign what's called an affidavit of non-prosecution, saying, you know what, I really don't want to go forward with this case after all. I didn't realize, because a lot of teachers, I'm at a lot of teacher happy hours, and they do not know some of the consequences of what these convictions can bring. So I just wanted to point you to the backs of some of the booklets. And Morgan, do you have them? Do you want to pass some around just so people can kind of take a look as I'm talking? But these are all online, and then we're going to leave a set for AYLA. But they have a lot of good information. We can't possibly cover everything, but it'll talk about your right to a jury trial. Just like in any other criminal court, your right to, the state has to prove its case beyond a reasonable doubt. The state and you can subpoena witnesses that you want to call if the case were to advance to the trial stage. Also, if the case advances to that level, you can file motions to suppress. So it kind of depends on how, if the child is saying very adamantly, I'm not guilty, the court might offer some kind of deferral or probation period. There's no probation, like probation officer, but it's like, hey, do these things and in 6 months and the case will be dismissed. But if that's not, in some cases that's not appropriate. A lot of times attorneys will go ahead and settle for and make the judgment that and advise their client that that's the best course of action. But a lot of times it's actually not appropriate, and an outright dismissal is what's needed. You can actually take a case to trial. So it's a great chance if you don't do criminal law to really get that window into criminal law and have the opportunity to get trial experience. To answer Morgan's question though, what will the process look like? So let's just say that we get this in the summons, and I think that I've talked to another municipal court judge who seems willing to put in the summons our information. And so what we would do is you would get, so Morgan's going to be the point person through AYLA, right? And so you would get information on a potential case. And if you decide to accept that case, we have a couple of administrative forms just saying, okay, we have a contract between TRLA and and the individual attorney. So by you contracting with us, automatically you get a couple things. You get technical assistance from us. You get malpractice insurance. You won't need it, but just in case, we'll sign a contract. And then we'll let the client know that it's actually now your client. We'll let them know your contact information. We'll send a letter to that client, and you will be meeting with your client. And so from that point on, we stay on as more of a, if you have any questions for us, and then at the end of a case, you would actually just submit like here's what happened, here's the order. The case got dismissed, or the case ended in a deferral, so dismissal after a period of time. And so that's kind of a real general summary. In terms of a timeline on how a case will work for a particular child, they will receive a summons in the mail saying, okay, you've been charged with assault. And so you have to show up, and like the judge said, your parent has to show up on this date. And so at the first time they show up to court, they're asked to enter a plea. It's like an arraignment, just like in a regular criminal case. And at that time, it kind of depends on the particular judge. Like the judge was saying, that each has his or her own idiosyncrasies. Sometimes if you plead not guilty in a court, right then and then the judge will say, okay, let's have a trial. So that's one of the good things about you being there, because that's not going to happen, right? You're going to say, well, we need a motion to continue, or we'd like to meet at a later date so that you have time to ask for school records or medical records, talk to different witnesses. And so you would show up after the initial arraignment. You would then show up to court, probably to talk with the prosecutor. So I'm not sure how it works in Austin Municipal Court, but each court has has certain days where you can actually call and speak with the prosecutor. You'll find out, okay, the prosecutor will be at the court Tuesday, Thursday at this time, and so then you go in and you would talk to that prosecutor and negotiate and try to get that case dismissed. If the prosecutor makes an offer that your client is not satisfied with, then the case would be set for trial. And so there's usually a pretty decent amount of time. It's not a quick turnaround. Once an attorney is involved, it'll probably be at least a month. And these do not require extensive discovery or anything like that. It's very, very informal. So you would, some of the discovery would be asking for medical records or asking for school records, trying to figure out what's going on. Asking for a letter from the child's counselor if the child is going through a situation of domestic violence. So that's kind of what the case would look like. Very, 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 very few of our cases actually go to trial because we are able to often get the case dismissed outright. And often once you say you're going to go to trial, a lot of times the prosecutor will then say, okay, just kidding, we're going to go ahead and dismiss your case. But does that answer the question? Okay.
Is discovery limited in any way? I mean, can you conduct depositions and put school administrators under oath to find out how often they use this as their sole disciplinary tool?
You can. I mean, it's based under the Code of Criminal Procedure, so it's the same, and rules of evidence. So you're using the same rules. The judge might look at you funny, but because it really doesn't ever happen, but that doesn't mean that it couldn't. And in fact, that's one of the things that initially we wanted to do. We wanted to go to, as long as our client said that he or she was not guilty, we wanted to go to trial, because then you call in and the custodian for this particular school district, custodian of school records, and you have them sit in court all day long until that case is in trial. You have that principal or the vice principal. The schools don't want to do that. They don't have the resources to do that. And so already you're making, just by one case, you're making an impact in that particular district. One of the things that you should know about Austin is that Austin ISD is actually, in some ways, more progressive than a lot of districts, in that, at least in terms of their policy and their regulations and the student code of conduct that lays out all the school rules, they have ticketing as a last resort now. Of course, there's exceptions, and how those exceptions are actually implemented is going to depend on how well they're being monitored. And so, I know the first year that regulation was in place, there was a huge decrease in tickets, but has since kind of crept up again because of how it's actually implemented. But just so you know, and I'm sure you saw that just by hearing from the judge, Austin does operate differently than a lot of other municipalities and counties in the state. So that's a good thing. I want to leave time for questions. I know I didn't cover everything that in the PowerPoint, but do y'all have any questions just based on what you've heard so far?
Yes. Well, with 2 months basically left of the school year, what realistically would you see us doing in terms of volunteering and getting some of these cases represented?
Well, a lot of the cases, will come closer to the beginning of the school year and towards the very end of the school year, actually, because kids are, high on hormones and adrenaline and ready to get out of school for the summer. So you do see some cases come in towards the end, and also you might have a case that was originally set for an arraignment in February, but the case is not going to actually be heard until later. So unlike a school discipline hearing that's immediately held after the incident, a lot of times kids are going to court several months later.
If we wanted to find out about trials that are set to occur in the near future that we could observe, is that some information we could obtain from you all?
Sure, yeah, absolutely.
But as Selena said, we almost never get that far, just because they get dismissed pretty quickly once you get involved, or a pretty good settlement agreement gets settled pretty quickly. So,
and you could also, we could also provide information though on just if you wanted to sit in on a docket call just to see what it looks like.
mm-hmm.
Okay.
Those are very informative.
I think one of the big things to remember when you're dealing with youth, especially youth who are more vulnerable and have special needs, is thinking about intent. Did a child who has an emotional disability really intend to, who has ADHD and acts on on impulsivity? Do they really have the intent to commit this particular offense? That's one of the big things. And you know, there's more information on special education in the slides and on our website. But when a child who is disciplined in school who has a you know, particular disability, there's usually there's due process for that child. Let's say they're being removed to alternative school. And in that school hearing, which actually you don't have to be an attorney to do, so if you have law clerks that are interested in special education that might be related to a ticket, you know, or if you, you know, volunteer attorneys, you know, that want to represent on the case. One of the things about special education clients in particular is if you have this due process hearing, a discipline hearing at school, if there's favorable findings saying that, you know, well, Selena's behavior was directly related to her disability, you can then go ahead and go to court and turn around and provide that to a prosecutor, and almost always that charge will be dismissed outright. So that sometimes what's going on in school or some of the other underlying issues can really help out. So just doing a minimal amount of questioning, it makes a big difference. And that's why I'm just so thankful that you guys are here and excited about this and want to take on these cases. Thank you so much for having us.
I just want to say thank you again.